Thankfully, this judge did the right thing and said, no, this is not what the scene wanted. I don't care if you all agree. No dice. So sadly, that was the closest this deal came to getting resolved. And maybe everybody, including the trust, would have been better off at saving 10 years worth of litigation.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen. Here's attorney CPA Joe Cordell.
Welcome to another episode of Life's Third Act. This week we're picking up with part 2 in the discussion of James Brown, his life, his legacy, and his estate plan. So we spent the first episode. You need to go back and watch that if you haven't yet, in order to have some context for this discussion. But now we want to focus on his death. So we took it up to the point where we included some of the circumstances he was in at the time of his death. We've talked about some of the players involved, which of course are family members who would have a claim either through his estate planning or by law called heirship. And now we want to talk about kind of what happened afterwards. And it should be telling to you that we're having to dedicate a show to what happened after the death, which is a little unusual. As a matter of fact, Marlea, I don't think we've ever done this before, have we?
No, I don't think that we have.
Yeah, I mean, this is just about the stuff that happened after the death. Mm-hmm. So, as many of you may suspect, this became contentious. His life was a bit of a mess. So we'll take a run at it to this extent. We'll sum up the fact that where we talked about last time were challenges toward the end of his life. He did have a drug and alcohol problem. He had issues of being incarcerated at least 2 times in the 80s and early 90s. His career was certainly not flourishing at the end of his life, but it was still there. And he was this, as we discussed before, he was a legendary worker. To this day, generations of young musicians will talk about, the James Brown work ethic. And he definitely was a guy who believed in working, and he continued to work. But he didn't take care, as he should have, of the product of that work. In other words, we know these stories around us every day. Marlea, how often does this happen? Even apart from rich and famous people, is that we will be busy making money, whatever our business is, whatever our job or profession is. We're going at it, and we're kind of proud of the fact that we're working so hard and being productive, and yet we're failing to give attention to the repository or whatever it is by which you accumulate the fruits of that labor. And in some cases, that repository can be a business, it can be a bank account, it can be a brokerage firm accounts. It takes the form of something that has financial value, an asset. And without attention to that, all that labor, while it generated some income for the person who was generating this wealth, the fact that it kind of dissipated and was not able to be enjoyed by those they loved and cared about, or the causes they love and care about in this case too, then it's a shame. So in this case, there was that. There was somebody who was busy with his career. He wasn't managing that well, though he certainly was working. And he was giving too little attention to his estate planning. But I will set the stage by saying that James Brown created an estate plan. He sat down with a lawyer. The plan on its face does not appear bad, meaning that we don't know the details of the irrevocable trust, but to his credit, James Brown did create an irrevocable trust, and he had some assets in it, but many of the assets that were to go into it were going to flow through the estate. Whenever you create an irrevocable trust, you can't just go ahead and stick assets in there. And those who watch this show know that I'm an advocate, especially for people who are vulnerable to lawsuits or contentious family situations and whatnot, that they go ahead and put assets in there while they're alive. Now, you do give up some significant or even substantial amount of control over those assets, but it's like you've put it in this vault. And if you've properly designed the vault, then it's secure. And you know that for the most part, with some exceptions, for the most part, whatever feuding and litigation might occur later in your life when you're incompetent, it may not be when you die. It could be that you go through a period of incompetence. And in this case, that wasn't the situation with James Brown, but then it happens when you die. So that wasn't done. There were some assets, we don't know how much was put into the irrevocable trust, but to James Brown's credit, he did go to a lawyer. The lawyer did advise him to create an irrevocable trust, and he did that. And he put some things in it. And the primary purpose of that trust was to provide education for children.
Everything you build for you and your family deserves protecting. All of those important assets you have worked so hard to acquire and enjoy, you want to make sure they're handled with care. At TuckerAllen, our attorneys will customize an estate plan that will work for you and your family's goals and needs. TuckerAllen, estate planning, probate, and trust administration. Visit TuckerAllen.com.
Were you surprised, Marlea, about the passion that James Brown had for the subject of education for children, for the poor?
I kind of was, but not really, honestly, thinking about it. I think it kind of was like, well, that's a little weird. But the more that you learn about him and his childhood, I think the more and the better you understand why he was so passionate about that and making sure that he was, funding that charity-wise and however else he could. Because he came, like we talked about in the last episode, he came from literally nothing, and he wasn't really offered a whole lot of chances that other kids were, and I think he just wanted to change that.
Yeah, and he didn't go to college. I'm not sure he finished high school. Do you remember?
No, I read that he didn't finish high school. I don't even think he had his GED.
Okay, and so he was very conscious of that, and unlike some people who become celebrities and move among educated and affluent people, sometimes people are not attentive to that, and it doesn't bother them, or they're not impressed with seeing education and cultivation among those around them. But I like that. I think that's a wonderful commentary on someone's perspective and values, that in his case, he was moving in a world where he saw people and was around people who had gotten educations, who had become more successful because of it. But I don't think it was so much about success. I think it was about just bettering yourself in many non-quantifiable ways. And he really wanted to be able to give that to poor children that grew up as he did. And so this was the primary purpose of this trust. This trust was not, oddly enough, it may have had some benefits for his family. I think there was a provision, incidentally, for education for some of his grandchildren. Not all of his grandchildren were included in his will, but those who are mentioned, there was a provision for that. But really, this was more about a legacy that would go way beyond his family, that would impact the lives of many people. So millions of dollars were going to be available. Even though all that money didn't go in originally, it doesn't change the fact that the will was designed to put that money primarily in that irrevocable trust. And you can do that. Again, for recognizing that this show exists in part to teach and educate you, to equip you, as well as entertain you. I make a note that unless there's a tangible reason that you don't want to give up some control now, and I realize there are those reasons, but it's generally better to secure your long-term legacy by going ahead and putting those assets in there. The moment they go in that irrevocable trust, subject to some explanations I'm not going to get into, but as a general concept, the moment that it goes into the trust, then you've bought yourself, you've acquired some insulation from a world full of threats and risks, not only from those outside, but those inside, those in family, and as well as the world around you. And you've secured it, you've locked it down, and by its terms, you can give benefits to generations, plural, even if you're not, don't have a huge fortune. So there was an irrevocable trust that was created, and there was a will that was created. This was going to be governed by the state of South Carolina primarily. Now, this is a little confusing. When we talk about this today, we're talking about several jurisdictions. We're talking about Georgia, where some of this litigation took place. We're talking about South Carolina, where most of it took place, and we're talking about California for some of the matters. So James Brown, he creates this will, he creates the irrevocable trust. He dies in 2006.
Yes, Christmas Day 2006, which is kind of sad.
He dies in 2006. And let's go over again the complexion of the family. There were how many children that he recognized? Can you kind of summarize that, and grandchildren?
Yeah, so he had three wives. He had married a fourth, Tommy Heine, and that marriage wasn't really recognized legally just because she had been married previously and hadn't actually gotten it annulled. So there's going to be some stuff that we see in the litigation from that. But he had 6 kids that he recognized, and then a few others did come forward throughout the litigation process, but none of them were actually deemed his children. And then he did also with we'll just call her his fourth wife. With his fourth wife, Tommy, he did have another child that was born shortly after his death, and his name was James II.
Okay, and James Brown, and is the right, incidentally, those of you who wonder, you don't have to support children when you're gone. So you can choose to give your assets to a few of your children or none of your children. In this case, that I think that the latest number I heard was that there were 9 children that he had. Most of those were outside wedlock. But anyway, 9 children, and there could be a few more that did not come forward for various reasons. But there were 6, though, that he chose to recognize in his will. And that we don't know the reasons, of course, for that, but I suspect that he had a chance to form a relationship with those children, and maybe there were problems with the relationship of the others. And there were several of the grandchildren, not all the grandchildren. I think 4 were specifically provided for in his will. But yet, again, most of his assets were to go to this charitable purpose. That was the thing that his lawyer and others made clear that were his priorities. So think about the stage being set right here. We have a guy who has been out of control. He's not been attentive, despite his wisdom in creating this document, which is certainly to be commended. Still, there wasn't the attention to business thereafter, to managing his assets appropriately, to assuring that the appropriate people are in control of things, and that he's made arrangements with his family as to what his intentions are. It's a little surprised that when he dies unexpectedly, I think it was a heart attack, wasn't it?
It was congestive heart failure, but they chalked it up to kind of like a few different things, but the main one that I've seen was congestive heart failure because of pneumonia. Yeah.
So there's a mess in his life in many ways. And when he passes away, it's not surprising that the relationships among these people end up becoming very contentious when a substantial amount of money is at stake. So when the probate process started, initially the people who were appointed, the administrators or personal representatives, they're called. Some of people know these as executors or estate managers. But in any case, whenever you have someone who passes away like this, the court will appoint someone, and so often that's provided for in the will, and I think that's the case here, who is to sort of manage or administer the estate to assure that debts get paid, that the money is properly distributed to the rightful recipients, and that they close out the estate thereafter. So it's an important role. But in this case, the same people were appointed that were also the people who are trustees for the trust. Now, you remember when you create a trust, you have certain people that you place in charge. And in this case, there were 3 people that were originally occupied this role. Apparently, James Brown trusted these 3 men. They had all been, 2 of them at least, had been active during much of his career. One had been a lawyer who had worked with him for some time. And then these people he also selected, not surprisingly, to be the administrators. lawyers who appoint themselves in this role when they do estate planning is discouraged, meaning that process is often one where lawyers are in a position to suggest themselves to their client, and not that that's unethical, but it has to be handled carefully, that the client has to know what their options are, and they have no obligation to include their lawyer as either a trustee or as an administrator or personal representative in an estate. That's always something that I felt that and did handle very delicately, and would first start with who the client would want apart from our firm when I was doing more estate planning. So I don't know how this appointment took place, but it kind of went sideways for various reasons. But for time purposes, we're not going to get into the details of this. This could easily be a 2-hour discussion of the various events and legal actions and rulings and allegations that took place for the next 12 to 15 years. So we're going to move kind of quickly through this and focus on the high points and the opportunities that we think are most informative and helpful to you. But in this case, these three people were appointed in both those roles. Immediately, members of the family objected for various reasons. As we mentioned a while ago, Tommy Heine was not, in fact, the wife, though she appeared to be and she claimed to be, but yet that claim was challenged by the children early on. And so you have the children alleging that she's not a lawful wife for, again, more reasons than we'll get into here. So she alleged that she was, and she started taking actions that she could take as a surviving spouse. And a surviving spouse, incidentally, is in a position to really disrupt estate plan. And this is a huge error on the part of James Brown to not address this. But again, for all the reasons I already talked about, distractions, probably not good mental health at the time, or even health of any sort at the time, it just was pushed off and pushed off. So it had to be settled afterwards. But James Brown could have settled this much more easily during his lifetime. Anyway, so he dies, and now you have a surviving spouse, a widow, who can lawfully take against the will. That's the way the law works. And we've talked about in here before that surviving spouses are in a special position. The court imputes to the relationship some joint contribution, whether it's tangible or intangible, a joint contribution to the accumulation of assets. And so virtually all states, whether they're common law states or not, are inclined to recognize that just the marriage relationship itself creates a marital estate of some value. Now, it doesn't mean that all the assets are owned jointly as husband and wife, but a good portion of them often are. And for a long marriage, typically 50% is regarded, even in a common law state, as well as community property. So in this case, we have somebody who's claiming to be a spouse who's going to take what's called an elective share. An elective share in South Carolina is probably a third. Those who are attorneys in that state may correct me that it could be as high as 50%, but that can really throw an estate plan out the window, because if you were going to fund a trust, if you had other intentions, priorities that you wanted to accomplish with the assets that you have, and all of a sudden a third is swept off the table, and then you have meanwhile claimants for other assets. So your plan can go down the drain. And in this case, it was a huge mistake to go into to allow this to happen after death rather than dealing with it before. There wasn't really a marital relationship before at the end, although they had been together as girlfriend and boyfriend since, I think, around 2000. Is that your recollection, Marlea?
Yes, that's correct.
Yeah, so they had, there had been several years of the relationship, but really they had lived together and cohabited, and originally it was a claim of common law marriage. I think there was some ceremony, though, as you suggested, Marlea. I think there was a ceremony, but the ceremony doesn't do any good if there's not a proper divorce from the previous relationship.
Yeah, no.
So anyway, the children, of course, don't like this person, predictably. So this is a conflict that was foreseeable. And sure enough, so lawsuits fly, petitions are filed in various courts. We end up in federal court. And among those things, which there were lawsuits about over the years, was one lawsuit related to allegations of corruption by the trustees. It turns out that one trustee in particular, the lawyer, was alleged to have taken hundreds of thousands of dollars from this, and apparently the judge was going to lock him up if he didn't return like 300 and something thousand dollars within a week or something. It was a really short time frame. And again, I haven't chased down all of these avenues of adventure, so to speak, regarding these disputes. But in this case, clearly this person was removed as trustee or resigned under threat of removal. And then the other two were threatened with removal because a trustee has a duty to oversee and report and take action against any fellow trustee who takes an improper action. So it's incriminating for the other trustees for another to be found to have done something improper, especially if they were negligent in any way. And it's a very high standard to where it's almost strict liability as a trustee if you fail to note and take action to protect this. The position of a trustee is probably the most solemn level of duty, the highest level of duty and responsibility in the legal system. There can't be anything that has a whiff of self-interest. So it's a very high standard, and many fail to keep it, even though they're trying and they do what they think is the right thing. It's such a high standard. Being a trustee is not something, incidentally, you should rush to agree to do if a family member or another approaches you to do that. But I can tell you that in this case, there was a resignation by two of them when they thought that, by the remaining two, when they thought that now they were going to be removed. But then they tried to get back on, alleging that they were coerced to resign. And then there was a lawsuit in which the relatives tried to remove two other trustees who were holding up a settlement. Then this ended up being, to tell you how big and frustrating that this litigation was, the Attorney General of South Carolina, this was in 2008, so this is a couple years after the death. I guess he was optimistic to think that it was possible to resolve this matter in 2 years. It was going to turn out to be off by about 13 years. But anyway, so to his credit, he tried to broker a deal between all these parties. And South Carolina has an interest. The state is regarded as having an interest in charitable trusts. Anything that is a charity or something that meets the definition of being for a religious and educational, public health purpose is something that the Attorney General has a right to intervene and protect the interests, since there is no specific beneficiary per se often. In other words, they don't name so much an individual as they do a purpose and a cause, in this case, to give money to needy children. So you can end up with no one to enforce a irrevocable charitable trust. So the Attorney General gets involved and thinks he has a deal. Everybody pretty much is willing to sign off. The spouse, the pseudo spouse, is going to get something. She's going to get paid off. The kids end up getting what really is more than James Brown intended. I mean, James Brown, as we talked a while ago, really wanted the bulk of his estate to go to this worthy cause of education for poor people, and yet the children were in a position as heirs to challenge the will as being the product of undue influence, in this case by the wife, to challenge the competency of the testator at the time, which of course is James Brown, to allege that there was undue influence there. So the children, as is often the case, are in a position to create a lot of expense and a lot of delay. There are ways you can minimize that risk, and we'll talk about some of those things as we wrap up here in a few minutes. But In this case, the children who really had nothing to lose to speak of, given that I don't know the exact percentage because it wasn't disclosed, but I suspect that 80% plus of the estate was going to this charitable cause that James Brown was very passionate about. Um, and incidentally was being held up by this litigation because remember, most of the assets were ending up going through the estate on their way to the trust. And that's where the danger of that is that they can get held up and sometimes irreversibly. So in this case, they were held up and they were held up for over a decade. But at this early stage, there was optimism that this case could be settled. So the attorney general's involved, attorneys representing the children had united. So the children, who also the grandchildren, would fall into that side of this multi-sided table. And then we had the putative wife with her claim. And we had third-party claimants with various, their creditors, their people who had contracts that they alleged that they hadn't been fulfilled during his lifetime, and they had to be fulfilled from the proceeds of the estate. In other words, supposedly legitimate creditors, in which case they would be paid first. So you had this multi-party situation, and seemingly miraculously, there's this deal cut. But the deal was cut because people were being paid off in a way that I'm not alleging it was corrupt. I'm just alleging it was contrary to the intentions of the testator. Remember, the one person whose priorities and whose preferences and desires should dictate all of this is the dead person, is the deceased. It's their stuff that they're leaving with instructions. So this was ultimately submitted to the court for approval, and this is unusual. It's very easy for the judge to simply look around the room and say, in effect, so everybody in the room's happy with this. All the parties are happy with this. And when the answer is yes, then typically it's done. Now, in this case, I think it was actually the trustees of the irrevocable trust who protested. And still the judge signs the deal because virtually all the voices are represented, and what's left is going to go into this irrevocable trust. So you don't really have a beneficiary in the room, so to speak, to plead their case. And the attorney general, remember, is advocating this deal. To the judges, to an appellate court's credit, the original plan was approved by that court, the trial court. It goes up to the Court of Appeals. And the Court of Appeals, South Carolina, I'm pretty sure at this stage, the Court of Appeals looks at it and says, and this is very principled, proper result. The court said, this is not consistent with what the deceased wanted. We have a will here that makes clear what the deceased wanted. We have a trust that's been created that makes clear what the deceased wanted. And just because all the people who are breathing, the people who are alive, are happy with this, the court said we cannot allow something to be done that's clearly contrary to the wishes of the decedent. In other words, the judge was respecting the document. It's refreshing when I see that happen because dockets of judges get busy and it's so easy to just push these things aside and say, yeah, everybody's agreeing. I mean, who's going to complain? Now, granted, in this case, you did have trustees, but it really wasn't, the trustees didn't have a personal interest and probably would not have pursued the matter any further. But thankfully, this judge did the right thing and said, no, this is not what the decedent wanted. I don't care if you all agree, no dice. So sadly, that was the closest this deal came to getting resolved. Maybe everybody, including the trust, would have been better off at saving 10 years worth of litigation. But I don't think so. I don't think the math works out that way, even though there's a ton of money spent over the next, this was 2008, so it's another 13 years. But anyway, I think that the judge made the right decision. So then what do you think the parties do? They sue the trustees of the irrevocable trust. And they're also acting as personal representatives, remember, the estate. At this point, you have some of the original trustees, but to their credit, they were opposing this deal because it was shortchanging the primary purpose of the estate. And so they bring in action for abuse of process. And so you have a new lawsuit that goes to, even went to federal court. Let me look here. Yeah, no, it wasn't the '08 case that went to federal court. The later in 17 was the first federal case.
Yeah.
The two federal cases, incidentally. So this judge threw it out, and the parties go to war again. So litigation to remove the trustees for screwing things up, litigation to have the wife declared not the wife, or the pseudo-wife declared pseudo. There was, claims also against the wife alleging that she was abusing termination rights regarding the copyrights. And additionally, other people that are coming in claiming to be heirs. So you have several suits that occurred during this period where somebody who was a child that had been born after a relationship that this person supposedly had, and they were alleging that this was a child, and that if the will is thrown out, then it would mean that's guess what, this person would be eligible to inherit. Possibly, not definitely. So among the other actions that accounted for all this money and all this time was there were actions filed to throw out the will completely, and the family itself brought that. Some of the family itself brought that. And so you may say, why would they do that? Well, remember, the will, as long as the will is valid, then the will is what's transferring a lot of the assets to this third-party trust. And I don't want to demean the family. I don't know what their motives were. But if the trust is instead, if the will is instead thrown out, then you have what's called intestate succession law. And that means under intestate succession, that irrevocable trust is not getting a nickel more than it got while he's alive. Another reason to think about making these transfers before you pass. But anyway, so if they had succeeded in having the will thrown out, we don't know. This was ultimately settled. But had they succeeded, then there's no claim that this third-party trust would have, and instead it would be the wife, a real wife, would get a substantial share. But the children were pretty confident that her claim to be a bona fide spouse is not going to survive. So it means that really all the assets would go to maybe not all the kids, but the kids that he acknowledged. So from their perspective, you can see, I mean, if we were thinking in purely mercenary terms, their strategy, it made sense that they would challenge the validity of the will. Mm-hmm. And also because they didn't want, maybe they did in fact believe the will wasn't valid, but they certainly didn't want to see this woman who claimed to be his wife get a substantial share, this elective share we talked about. But if she turns out to be the real wife, then suddenly she's going to have a chunk either way it goes if she had been the real wife. But again, their litigation, their action filed to allege undue influence, so a will that wasn't proper, and as a result, he died intestate would be that argument. That when combined with finding that the spouse was not the spouse, you put those two facts together, and that's when you end up with the best advantage for the children. So the spouse was filing her claim that she was to get the assets under an elective share scenario. So that was part of the litigation that was going on. As far as the assets that existed, there's a big dispute about that. What was the range that you read about, Marlea?
I read a couple of different ones, but I read something that was upwards of I think 80 million, but that was way out of the ballpark, I think.
Well, I read 100, but you're right. That was the upper end.
Yeah.
That was the upper end. And some were saying that at his death that it was closer to 5 million.
Yeah.
It's funny that the similarities here to a case that we did recently, and I encourage our viewers to watch if they haven't already, is Whitney Houston. Mm-hmm. There are a couple of parallels. One we're going to come to here in a minute, but the fact that when artists such as this die, depending on the condition of their life at that time, the condition of their fame at the time of their death, they may have an estate that on its face looks like it's worth $5 million. In Whitney Houston's case, it was argued that it was of negative value, that actually, if you sold everything, you still would have creditors that were unsatisfied. So in this case, there were I think the lowest number I read was 5 million. But what do we know about the nature of intellectual property, especially for people who have potential legend status? And I think James Brown, it would have been clear at that time, even that he had a claim to a big future and a big legacy, and continuing popularity over potentially multiple generations, which we've seen already, but probably 2 generations, maybe one at least since his death. So in this case, I think that though the number was initially set at 5 million, I think it ended up closer, as you said, to 80 or 85 was the estimate. But again, that hinges so much on how the estate is managed, and the estate, has to be managed like a going concern business, which means you have to have professionals involved, you have to have in place employees who have expertise in this area, or you have to contract it to an entity that is engaged in that business and has that expertise, because the value of a legacy like that is something that has a shelf life if it's not tended. And it still has a shelf life, but if it's properly cared for, that shelf life can be many decades.
Yes, yeah.
And Elvis is a good example of that, many decades. And I don't know that Elvis is slowing down any in terms of his popularity.
No, I don't think so.
So there was huge potential for James Brown. He was really special in a lot of ways. And he had a very loyal fan base that, because of his role in civil rights issues as well, he really had the potential to grow as a figure that would be popular and of whom there would be continuing fans. So everyone knew the amount of money was going to be substantial, whether or not it was at the moment. And I think that part of the problem during this period of time was there wasn't the proper management. So you didn't see the estate managed the way it should be. So you go through a period of 10 years where there is just neglect. It's the nature of litigation. It often happens even with businesses where you have somebody in the business who is fighting a lawsuit and who cares about the business, but there's such distraction and uncertainty that the reinvestment and the attention to detail that would otherwise occur is impaired, because you wonder, to what extent am I wasting my time and my money on this business? Am I going to lose this lawsuit? If I am, why would I do such and such, or why would I invest in this or acquire that? Especially, why would I acquire that? So the opportunities for growth, are impaired. And the same thing happens with intellectual property too. There was not a centralized management, because remember, it wasn't in the trust. It was outside the trust, and it was still sitting in the estate, and it couldn't be properly distributed until the gavel went down on the final outcome. So here you have an estate that's tied up for over a decade. I mean, think about that. I mean, Grant, most of you listening to this, watching this, are not in the situation of James Brown. And that's a double-edged sword, but it's too bad regarding your assets, but it's fortunate regarding many other things, meaning that you in your own situation, it's possible for you to have years of litigation, maybe not decade plus, but years. It's not unusual at all. Happens all the time. And people who fail to take steps to prevent it, then, it's ultimately, whatever it was their priorities were when they left this world, that were based on the accumulation of their efforts over a lifetime, those were thwarted. And they go in directions, and they go to people that you, if you're the deceased, that you would not have wanted. So in this case, thankfully, there is a good outcome, but it not without great expense to the estate. So the estate was kind of in limbo during a period of time. There was litigation even relating to rights that were being exercised by people while the case was pending. So there was one lawsuit that was filed in which the children alleged that Tommy this woman, Heine, had actually tried to exercise her termination rights on copyrights that would have preempted the rights of the children and that would have excluded them from any proceeds. So let me tell you just real quickly about termination rights. They were a big issue in this case, and they commonly are. This has come up before as we've talked about people's estates. Termination rights were something that was passed by Congress in an effort to assure that people who are victimized by contracts early on in their career, artists notoriously, musicians, they're approached when they're young and hungry, and they sign deals, multi-year deals, sometimes forever deals, where they sell the copyrights or the revenues, the royalties that might have come from their intellectual property. So it relates more often to the copyright royalties versus recording royalties. Recordings is a separate piece of compensation, but what you own as an artist of a creation, you have the ability to sell that. And many of you know that a number of artists have been cashing in. Bob Dylan sold his songbook. I don't know, it was some over $300 million a number of years ago. So it's commonly done, but the Congress passed a law in which they know that people can be victimized early in their career, and they wanted to give them an opportunity to free themselves from an onerous contract. And that opportunity comes if it's something that was signed after 1978. That contract comes after 35 years. It was before 78. Don't hold me to this. I think it's like 54 years. But the important thing you need to know from this, for our purposes, is that James Brown had signed some contracts that were really unfavorable to him, and really the value of the royalties would go way up if they were not subject to this contract, if they could be remarketed and sold. So that was an opportunity that matured in this period between 2010 and 2020 for a number of contracts that he had signed. So during the pendency of this case, though, you don't have in place the sort of management that can assure that assets are protected and that they grow, and that when you do have termination rights that ripen, then you can exercise them in a timely way and in a way that is most beneficial. So yes, it has to be timely, but then what do you do after you exercise the termination rights? In some cases, it makes sense to re-sign with the same people at a much higher price. In some cases, it's better to shop and go elsewhere, but that's an important decision. If you don't re-sign with the correct parties, then you can end up again, losing unnecessarily value. So we did have some rights that were maturing, and supposedly the claimant, the pseudo-wife, alleged that she had the right to exercise these termination rights, and apparently did for some of his songs. So this issue will become significant later when we talk about what happens by a court in 2022 that will affect this subject. But it's important then to understand, for these reasons and others, that there's a price that was paid by this estate over this period of time in which things languished. Lots of money was spent, much of it being paid by the estate, incidentally, not all of it, but much of it. If it were legitimate claims, then likely the court's going to allow the proceeds to come from the estate. And certainly if the estate's being sued and it's defending itself, then that's legitimate. And if the state brings an action and it's legitimate, then those fees would be paid, unless the court orders that a wrongdoer or a losing party pays. So I can't tell you how wasteful and expensive this is. And finally, I'll fast forward. We could easily take another hour talking about issues in litigation. So let's fast forward. Two important things happen that kind of bring this estate litigation to a close. One is that in 2022, a federal court no less, ruled that the claimant to be the wife, Tommy Heine, that claim was invalid, that she in fact was not properly divorced, and that despite her intentions and her complicated legal arguments, that ultimately she cannot be a spouse. So that cleared that issue, which was a huge issue in the litigation, pushed that off. Now, incidentally, that also raised an issue whether the termination rights that she exercised since she didn't have the standing to sign those contracts are probably not valid, which means that they can still be exercised by the family. So that's subject to some time limits and whatnot. But it appears that they will be able to undo what she did if she signed it in an illegitimate way, because she didn't have standing to sign those contracts. So that was one big outcome. The other was that finally there was a settlement in which all the parties came together, and there was a sufficiently large contribution to the irrevocable trust, which, remember, that was the problem early on. But now that we get, what I think happened is that once we get Tommy out of the way, Tommy Heine, then that portion of the proceeds that she was going to, hold hostage to any deal, that becomes available to satisfy everybody else. So it ends up that I think that the family got 20 or 25% of the total estate to divide between them, which includes 5 surviving heirs, sons, 1 that had passed, so 6, and then some grandchildren. So that's good. We know that a substantial part. That was more, I'm confident, without having the documents, that was more than was originally intended by James Brown. But nonetheless, it was definitely, I think, an outcome that is important, because it's the only way we're going to get this resolved. And the family, they are his family, and they've hung in there a long time. They will help advance his legacy, I believe. And I think that it finally frees up the money to go to the trust. In order for the irrevocable trust to get what it wanted, it needed to be prepared to deal. And ultimately, the court concluded that a sufficiently large amount is going to this charitable purpose that was so important to James Brown that they would approve it. So supposedly, I don't know if it's been inked yet, but the latest word is that a settlement was reached, and that was late 22, wasn't it?
Yes.
So anyway, what can we learn about this? I'm gonna go through this kind of quickly, but I've talked about, as we've moved along here, kind of the points that I think that you as a viewer should think about. I guess we could say overall that it's not enough to simply create a trust and to create a will. We talk about, you got to create it, and that's true. But that is not enough. You have to fortify that estate planning with some additional steps. Among those steps are placing in control people that you can trust. And often that includes some sort of corporate or institutional trustee. Same thing for a person who's an administrator. You've got to be able to trust these, and they don't have to be the same. And unless you have a whole lot of trust for these parties that you've named, you may not choose to name the same for both. There are some estate planners who would say it's good because there's a consistency, but it does place a lot of power in a few hands. And in this case, I would, as we see, it was better to have built reliable corporate trustees and then separately had an administration plan. So fortification is critical. The terms of the trust, the payout, we talked about that. You want to pay out over time, not immediately. You also we mentioned the fact that it helps to go ahead and fund the trust. Put the assets in it. Think of the benefit that would have happened if those assets had gone in already. It's still possible to challenge a trust, 10 years later or 5 years. In this case, it would have been like 10 years later. He had done this a number of years before his death. That's very difficult to challenge. When you've already placed something and you've transferred assets to it, you've watched it manage and do those things, it's very hard to allege that something's happening you didn't know about. Whereas a will, by contrast, you're gone and you didn't know what was going to happen, one could argue. So wills are much easier to attack, is the bottom line. Another thing is, there has to be some life management. It's not enough to simply shuffle documents and create the right contracts, to create the right terms for a trust, to appoint the right people. Those are critical. But in the absence of some level of life management, at the end at least, if not throughout life, then you can still screw up an estate plan. In this case, let's assume that we had great trustees appointed. Let's assume that in this case, we still didn't put the assets in the trust. We put the assets in the trust, as I said, that's powerful. But let's assume that for a lot of reasons, people can't do that. I mean, you give up control of your assets and maybe you'll need them. That's what a lot of people think. I found that clients are, unless they're real wealthy, they're reluctant to put a lot of money into an irrevocable trust because you do lose significant control. So let's assume then that the money was not placed in the trust, that it was considered, but ultimately the client, and understandably in some cases, said no. So the client says, look, it's going to end up in the trust. I've created a good will. I have a will that is good. And I think that the money will go there immediately after my death. That's my intention. And I've written a good plan. Even if all that is true, that there's a good plan, to the extent that you go out of this world with kids that may or may not be your children, relationships where it's unsettled, a person that's living with you that might have a claim to be a common law wife, depending on the jurisdiction, a question about whether a divorce was ever valid or not, a question whether a marriage was ever valid or not, conflicts that exist between your children as well as your spouse and your children. If you have a second spouse, you can anticipate there'll be problems there. And if on top of this you have a business or going concern assets that require active management, an example of a going concern asset is what we've talked about here, where you have royalties and other intellectual property that has to be managed. So a brand, a name, a likeness, all those things have to function as a independent business essentially. But choose your own example of a business. Whether it's a plumbing business, whatever it is, professional business, that business needs to be strongly fortified in order to avoid an attack that is going to impair it, as I discussed a while ago, or make the business worth nothing at the end of all of the conflict and the chaos. Well, when you go out of the world, despite what you think is a good plan, but you have life circumstances that are just chaotic or that are notoriously invitational to conflict, then in that case, it just wasn't enough. I don't care how good your plan was, you needed to do more. You needed to clear up some of these problems in your life. And for everybody, the conversation will be a little different because how you clear those up varies. And sometimes you can simply take certain legal actions. But to the extent, though, that it relates to interpersonal conflicts, then I can tell you it heads off a lot if you have conversations with those people in advance about what your intentions are, to where they know it's settled that you're going to do it, and you maybe even film. It's not unusual to video your execution of your documents to assure that claims of undue influence or that you lack capacity to make the will, those can be thwarted pretty quickly. But a family meeting is huge. No guarantees, but I would suspect, based on my experience, that 50% of the conflict that would have happened goes away because it's clear to everybody in the room why you did it. Whether they agree with it, they're not going to agree with it, those who are unfavorably impacted, but they'll understand why you did it. And it'll be clear that this is not the product of undue influence or fraud of some sort. So that's powerful. Another thing you can do is, to the extent there are challenges that exist to whether you own a particular asset, maybe an underlying title dispute to real estate, maybe there's a pending litigation that could have significant impact on the value of a business or some other asset in the estate. These are all things that you need to clear up. It's not enough to just go to your lawyer and prepare a wonderful irrevocable trust and a wonderful will. These things have to be settled, and they'll either be settled during your lifetime or thereafter. And I would argue that during your lifetime, you're far more likely to get a favorable outcome in terms of your priorities as opposed to somebody else's. You're far more likely to get a favorable outcome than if you push it off and figure your heirs can deal with it. And they will deal with it. It's just incredibly inefficient. So when when I look at some of the things that I would suggest to fortify a will, other than what I've mentioned, uh, there's something called an interim clause, which is a no contest clause. It's commonly used. Courts tend to construe them very narrowly, but they do enforce them. They're enforceable. But courts will construe them narrowly. If somebody challenges not so much the validity of the will, but maybe they challenge an interpretation of it, that's generally outside the scope of what would cause someone to forfeit their interest, where they're saying, I'm not challenging the will, I'm challenging what the other side is saying was intended in this will. So that's different. Another thing that many states will permit is a challenge to someone's capacity to make the will, because that goes to whether or not it's a valid document. And if it's not a valid document, then the court doesn't even have subject matter jurisdiction to rule on this or to make a distribution based on this document if the person lacked capacity, because that's one of the core elements for you to have a valid document. So for someone to raise that point, many states will not allow them to be punished if it's a bona fide claim. So if someone has a bona fide reason for saying that you were incompetent or a victim of fraud, then some states will allow that to override an interim clause. Some states will say only if you win. And of course, if you win, by definition, the clause isn't valid because you would have said that the will's not valid. Other states will say that you can, there's a safe harbor for you to bring a matter to the court, and this is true in almost every state. There is a safe harbor for you to bring an action first to the court and then ask the court in advance in your preliminary action, is this going to, if we proceed on this subject or this issue, is this going to cause me to forfeit my interest? So these are examples of how a no contest clause has its limits, and it's not as powerful as some of us might think. When we hear about it, we think, oh, if I put in that in there, there'll never be a contest. One other point, a no contest provision only is helpful if somebody's getting something. So if you're going to use a no contest provision, you got to give, the heir or the claimant something. Otherwise, there's no incentive to not do it, because if they lose what they're going to get, they're going to get nothing anyway. So you have to be prepared to give some significant amount that essentially constitutes a bribe, so to speak, to say, if you challenge this now, you're going to lose that. So these are my thoughts. I could go on and on about this, but Marlea, what would you add anything as we wrap up? Or any questions you would have of me?
No questions or anything. I think you kind of cleared up everything that I was thinking about. But I just think, everybody needs to take this into account, because this was 15 years worth of litigation, and it could have all just been completely avoided had he done, a couple of other different things, or had he actually really paid attention to what he was doing.
Oh, one other thing. Why don't you take a minute here and tell them about a good development regarding the management of the assets that has happened recently?
Yeah. So if you listen to our Whitney Houston episode, which again, we encourage you to go do, you will know of the company Primary Wave, and that they are taking over a lot of different estates, celebrity estates specifically, and they're taking over the royalties and managing all of that and their names. And this one actually took over James Brown's estate as well.
Yeah, and in fact, the person we talked about before that was pivotal in negotiating that deal and is still the CEO, to my knowledge, of Primary Wave, which is Larry Mestel. Anyway, his estimate was $90 million. This was a $90 million deal, but this was signed in 2022. It included all the music rights, the real estate, control over Brown's name and likeness. They're going to really bring that comprehensive approach that I mentioned a while ago is critical to being able to manage someone's legacy. You got to have professionals. The day when you're going to have a family member go out and do that, those days are gone. And thankfully for James Brown's legacy, is we have a company that has a great reputation coming in to take over and manage primary wave music. So this will be huge for the family. It's going to be also huge for the trust. We don't know how those revenues will be allocated, but I'm sure some of that revenue will be going to the trust.
Yeah, and I find that just so interesting. I think it's like awesome what they're doing, especially because, like you said, it's really hard for families to manage that. A lot of them can't come together to do that or, set up foundations or anything like that. And so they kind of just lose that name that really like got them there in the first place. And I think Primary Wave's kind of putting a stop to that. So we're letting celebrities who were really big live on through them.
Yeah, it's a marvelous development. Okay, boy, this has been, we could say so much more.
Oh, yes.
Mercifully, we're ending it here. But James Brown is a huge figure in contemporary music. I think he's going to have a long legacy. I think that this will end up being a lot more than a $90 million deal.
Yeah.
But time will tell. Anyway, this has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.